Next case is In Re DB. Each party will have 15 minutes to present their argument. The appellant may reserve 5 minutes for rebuttal. Counsel, how long would you like to reserve?
2 minutes, please.
2 minutes, very good. We'll note that. As we noted earlier, clock over there, please look at that. I'll try to let each of you know with 1 minute left in your initial time. I will not let you know the 2 minute time of any warning about that. Sorry to be recording. When you come up, please state your name, tell us who you represent, stay behind the podium so we can visually record you and also auto recording as well. You do obviously know we have a minor here. Please use initials for the minor or any victim in this case if you would. We read your brief and are ready to proceed whenever you are.
Good morning, Your Honors. May it please the Court, Joseph Shelf from Summit Legal Defenders on behalf of the appellant, DB. Your Honor, I'll reserve 2 minutes for rebuttal. I'm happy to rest on my briefs for the fourth assignment of error here regarding the sufficiency of the evidence. Of course, I'm also happy to answer any questions the Court has, but I'm going to focus my presentation on the first 3 assignments of error here, starting with the first, that the trial court erred in admitting CB's statements in violation of the Ohio Confrontation Clause, or the Ohio Constitution's Confrontation Clause. And I think really the Ohio Supreme Court's 1993 decision from State versus Storch settles this question. It's the same factual situation that we have here, and it's the exact same legal issue. When you have a child witness who's under 12, and the allegation is about sexual conduct, the only way to get that testimony, that child's testimony in, aside from face-to-face testimony as required by the Ohio Constitution, is under Evidence Rule 807. And neither the trial court nor the state invoked that rule here. And Storch is clear. It has not been modified, it has not been overruled since it's been decided in 1993, but it's clear that Ohio requires face-to-face confrontation, at least in this situation, and that Evidence Rule 807 is the only way to do that otherwise. In fact, Storch rejected, the context that case was decided in, was that the trial court had admitted the child's statements under Evidence Rule, under the hearsay exception 8034 for medical diagnosis or treatment. It's the exact same situation that we have here. And Storch said, no, that's no good. In fact, it's the entire reason that the Storch court even took up that case is because between what the Supreme Court of Ohio decided in 1990 in State versus Self and what the Storch court decided in 1993, in the meantime, the U.S. Supreme Court had said, well, if you meet, in Illinois versus White, if you meet a well-rooted hearsay exception, that's good enough for the federal confrontation clause. And the Ohio Supreme Court said, hold on, no, that's not good enough for the Ohio Constitution because of the different the right to confront witnesses face-to-face. And so for that reason, for that textual difference, what Storch said is that well-rooted exceptions to hearsay are not sufficient to satisfy the Ohio Confrontation Clause. You need either, again, to follow the strict procedures of Evidence Rule 807 in order to comply with the Ohio Constitution, or you need live testimony.
And I'm sorry, I don't recall from the record, was the Ohio constitutional issue raised in the trial court?
Yes, so there was a general confrontation clause objection in the moment, and then in the objections to the trial court judge, there was both an Ohio and a federal constitution argument raised in those objections.
Does it make a difference if it's not raised at the hearing, but only in the objections?
No, because I think the objection at the hearing covers that, says that it's a confrontation clause violation. There were no arguments, there were no specific arguments that would only apply to the federal constitution that were raised in the trial court. They were general confrontation clause rights. So I don't think we're in a situation where, like this court has held in a Rule 29 context, for instance, that if you make specific arguments, you waive the rest of them. But if you make general ones, you preserve all. And I think here we've got a general confrontation clause objection, and then specific arguments under both different arguments under both the Ohio and the federal constitution in the objections to the trial judge after the hearing. And because the trial court here admitted those statements in violation of the Ohio Confrontation Clause, that admission is not harmless because, as both the magistrate and the trial court noted, really the only testimony that DB touch the victim's private area in a way that would satisfy the elements for gross sexual imposition comes only from CB, from the child witness. So without those statements, there's insufficient evidence then to establish all the essential elements of gross sexual imposition, and so that error is not harmless. Also note that the burden is on the state to show that a constitutional error is harmless beyond a reasonable doubt, but here the state makes no argument under the Ohio Constitution. Doesn't cite it once, doesn't cite State versus Storch once in the briefing, and doesn't make any argument that this error was not harmless beyond a reasonable doubt under the Ohio Constitution.
Counsel, but the state does cite State v. Arnold, cites many cases from this court. We've had this issue multiple times. And obviously, we have to look at each individual case, but the Ohio Supreme Court seems like it's pretty lenient interpretation as to what is medical diagnosis and treatment exception for a child sexual abuse victim, saying that the identity of the perpetrator, the age of the perpetrator, the type of abuse alleged, the time frame, all those things are relevant. So what, if we have all this case law that says they can be acting basically as an investigator as well as a treatment provider, what do we do? How do we get around that here?
So I think, so all of those arguments, including in Arnold, were challenges directly under the federal constitution, not the Ohio Constitution. So I mean, I did look back at the briefing in Arnold. The Ohio Constitution is mentioned just once. It's just saying there's this confrontation clause violation there, but there's no separate argument under the Ohio Constitution there. So all of those cases, Your Honor, that have talked about whether something's properly admitted under 8034, and for the same reason, whether something is non-testimonial under the federal confrontation clause, those arguments don't apply to what the Ohio Supreme Court said in State versus Storch. Storch, right, said, hearsay exceptions aside, right, the way that you get this particular testimony in is only under Evidence Rule 807 or via in-person testimony during the trial. And I think it matters that in Storch, the child witness that they were talking about there, who they said had to testify or comply with Rule 807, was 3 years old. And here we have, so this is a 7-year-old witness in this case. I will note that this court has cited Storch 9 times since, and this is, I think, also how, not that this is a way around it, right, but this is just a different challenge than what the court has addressed before. So this court has cited Storch 9 times, but in 5 of those cases, there was no challenge under the Ohio Constitution. They were challenges under the federal Constitution or specific to whether a trial court complied with the strictures in Evidence Rule 807.
Counsel, let me ask you in regard to Arnold, did the Supreme Court say in a footnote or anywhere acknowledge that they were not deciding this under the Ohio Constitution?
So it didn't say that explicitly. The entire analysis, though, is under the federal Constitution. And it does talks about separating what the care center's dual purpose is for the purposes of whether statements are testimonial or non-testimonial. That's a federal confrontation clause test. That's not in Ohio. There's no case that says that test applies specifically to the Ohio Constitution. All Arnold said about the Constitution is in one sentence, and it's a quote from State versus Self in 1990 that says that the federal and the Ohio Constitutional Confrontation Clause rights are coextensive. But Storch, which was decided 3 years after Self, explicitly rejected that proposition because of what the Supreme Court of the United States had said in the meantime. And explicitly rejected this idea that meeting a well-rooted hearsay exception means that you don't have to deal with the Constitution itself separately. So those are the ways that this case is different than any of the cases that the court has addressed before, and particularly with the Ohio Confrontation Clause challenge here. For those reasons, the court should sustain the first assignment of error, say that CB's statements were admitted in violation of the Ohio Constitution, and therefore reverse the conviction because there's insufficient evidence once those statements are excluded. But even under the federal Constitution, those statements should also be excluded. And this argument really applies to both assignments of error 2 and 3, because under the federal Constitution, as we've just been talking about, right, meeting a well-rooted hearsay exception such as 8034 is the same as saying those statements are non-testimonial and therefore properly admitted under the federal Constitution. But that's not what we have here. We have statements that were elicited for an investigative purpose. And the reason that we know that is because the social worker here said so. Said so twice. Said so once under oath at trial, said, and this is in the transcript at page 64, said, oh, the reason that I ask most of these questions about what happened, who the perpetrator is, exactly what the perpetrator did, the reason I ask those questions is because police use these interviews for their investigations. She also said at the beginning of this interview, before asking CB anything about what happened, Right? I'm going to ask you these questions because police officers, attorneys, social workers are going to review this and look at it. Does not say, you're right. So that's CB's mindset when he's answering questions from the social worker here in the care center interview, is that I'm answering these questions so that the police and attorneys can look at this stuff. It's not so that I can pass this information along to the doctor, right? What the care worker says is that after I do this interview, right, you are going to go see a doctor, but there's nothing that she says that suggests that the reason she's collecting information is for that, right? It's actually suggests that this is a detour to the medical part of why you're here at the hospital, right? I need to ask you questions because police and attorneys and social workers are going to review this, not medical professionals. The police believe the same thing. They talked to, and this is at transcript page 16, there's testimony that the police interviewed everyone at the scene except CB. And the reason they didn't do that is because they knew CB would be interviewed by this care center worker there, which again is evidence that these statements were elicited by the care center interviewer for an investigative purpose.
But the case law knows that. The case law that the state has cited, if you look at Arnold and all those cases, they know that. And the whole rationale is that they don't want 15 people interviewing a child sexual abuse victim. Now, whether that's right or not, that's what the Supreme Court has said. So I'm not sure I understand. Like, for instance, you said that they haven't ruled that there's no greater right or haven't ruled in the issue of the Ohio Constitution. But in Arnold, they said that there's no greater confrontation rights under the Constitution. So I just went back and looked myself just because I was curious.
Yeah, no, absolutely. I mean, that is what Arnold says. What it relies on for that is state versus self, which was decided before. I understand. Before
they were
storage.
Also aware of their own case law.
Of course. I mean, there's no analysis in Arnold that says, that says this testimonial, non-testimonial thing is specific to the Ohio Constitution. There's no analysis specific to the Ohio Constitution in Arnold. It's all federal confrontation decisions. And I mean, the Ohio Supreme Court signaled last year in State versus Carter that it thinks, the parties didn't raise it in that case, but it does suggest, both in the majority opinion and in Justice Fisher's concurrence, that that the textual difference between the Ohio Constitution and the federal Constitution means something. And that, again, that case wasn't the right vehicle because the parties didn't raise it there, but, it does suggest that there is this difference. There's nothing in Arnold that, again, or any other case, right, since Crawford or Davis, that undertakes an analysis specific to the Ohio Constitution that says, given this sea change in Crawford and Davis, they're still coextensive, right? All those cases call back to self, which was decided well before Crawford, which was decided before Storch, and is inconsistent with the reason that Storch took up that case, is given the development of the federal Constitution jurisprudence in the meantime. So I think, and to your point, Judge Carr, about what Arnold did is, yes, of course, it said that, these care center interviewers, that one of the reasons is because they don't want the child to go through multiple interviews. But it also said that given the care center's dual purpose, there has to be an analysis, statement by statement, of whether these statements are testimonial or whether they're for medical diagnosis or purpose. So it's not just a blanket, get out of the confrontation clause free situation where, because a care center interviewer is asking the child questions that a doctor might rely on down the road, it's what is the purpose of getting those statements in the moment. And that analysis the trial court didn't do here. It didn't look at whether each statement was for an investigative purpose. I think there's, again, the evidence that we have from the care center interviewer that that's the reason that she was asking those questions is for the police. That is the hallmark of an investigative purpose. And so for that reason, not only were the statements, setting aside the Ohio Confrontation Clause issue, the trial court erred in admitting these statements under the federal Constitution, and also for the same reasons under Evidence Rule 8034, and should be excluded for that reason too. I'll reserve the rest of my time for rebuttal. Thank you, Your Honor.
May it please the court, Kevin DiMartino on behalf of the state of Ohio, the appellee, we are asking that this court affirm the juvenile's conviction for sexual imposition The state will respectfully submit that the case that is dispositive with regard to this analysis is State v. Arnold, and that is the reason why the state did not, or the trial court did not engage in an analysis under State versus Storch. These statements were non-testimonial, therefore the confrontation clause was not applicable. Under evidence rule 8034, these were statements that were made for medical diagnosis and purpose. The trial court did go through on the objection of the juvenile and analyzed all of the statements that were made and did exclude, as counsel noted, that should be done, looking at each statement, and did find that 2 of the statements were not for medical diagnosis and treatment, and those statements were excluded, and the trial court found that they were harmless, and the state would respectfully submit that they are harmless. With regard to these particular statements with regard to who the perpetrator was, the allegations of the facts that support the sexual context of what happened, those things have been determined by this court as well as the Ohio Supreme Court to be things that are necessary for medical diagnosis and purpose. And it is irrelevant what the care center interviewer may have said as far as why those questions are asked, because those questions are appropriate. She also testified that she followed the procedure, so even if she was mistaken as to the reason for those questions, she did follow the proper procedure. And those questions.
In what case, I know there's obviously like Arnold and other cases talk about, they can be for dual purposes, obviously. But the appellant here seems to be arguing that a court should look at each statement individually and make that determination, which was not done.
Right, I don't think there's a case that specifically says that, but I do think that when you look at Arnold and you look at State versus Romo from this court, the court is going through those statements each time. I think it's just inherent in what you're looking at,
And what about the fact that most of the cases that I remember, the interviewer, I understand it may not be binding, but they do say that this was for medical diagnosis and treatment, and then they explain the procedure. What about when somebody does exactly testify, well, no, this is her investigation? Why don't we take them at their word?
So I do.
She was the professional.
Right, I do believe she said it was for medical diagnosis as well. That she definitely did say at one point it was also going to be used by police and lawyers and social workers, which cuts against the fact that she's not saying it's only being used for investigation. I think she's giving the full purpose of what these things could be used for. So I don't think she said it's specifically or it's only going to be used for police. That's a mischaracterization of her testimony. She did say it was for police, but she also said also for medical, also for social workers, or also for lawyers. So to pull that out, it is not a fair characterization of what she was doing. Even, like I said, even if she was mistaken about it, she still asked questions that were appropriate. The mindset of the individual in asking the question also isn't relevant to whether or not the information that was being given was for a medical diagnosis and treatment. This child wasn't 3, as pointed out, that child was 7, which is an age where it is presumed that the person would have competence with regard to other reasons for testifying. These would fall outside of the hearsay exceptions under the statements for medical diagnosis and treatment under evidence rule 8034, as well as the business record under evidence rule 8036. And just briefly with regard to the amount of evidence or the sufficiency of the evidence to show the sexual imposition, you had the testimony of the child's mother who observed the perpetrator rolling off of her son and the statements that she said the child made, and then you also have the child's statements that he touched his privates, and then you have the evidence that it wasn't accidental based on the fact that he was hiding what was going on underneath the blanket, and then he denied what happened. And the mother's testimony was also there that the perpetrator was pulling up his pants when he rolled off the other individual, and her child said he was, quote, humping him. So there is sufficient evidence, not just the evidence of the child, but also the child's mother who witnessed part of what occurred. The state would respectfully ask that this court follow the case law that has been decided from the Ohio Supreme Court in State versus Arnold, as well as this court's line of cases with regard to medical records that are contained within the care center records, and if those statements are made for things that go to medical diagnosis and treatment, which include who the perpetrator is, the age of the perpetrator, the acts that constituted the offense, Those things would make the statements non-testimonial. They would be outside the confrontation clause, and they're also admissible under the medical exception under Evidence Rule 803, and we'd ask that this court affirm. If there's no further questions, I rest my case. Thank you.
Very kind.
Thank you, Your Honors. I'll try to make 3 quick points here on rebuttal. Judge Carr, to your question about what case says that you need to make a statement-by-statement determination, the Supreme Court of Ohio said that twice last year. We've in Wilcox, and I think the other case is Smith. They're both cited in my brief, though. I think that comes from Arnold also. The second point I'll make is that it's not irrelevant what the reason that the investigator asked these questions. That's explicitly one of the tests. In fact, Arnold says that you need to look at, and this is related, right? It's not about what the only reason for these questions or for the information is. It's about what the primary purpose of asking them is. And so when the person who's asking them admits that the primary reason I'm asking these questions is for police to look at them, is because the police use these statements as part of their investigation, that suggests strongly that the primary purpose of those questions and the information elicited is for investigative purposes. It, of course, can be secondarily used for something else, but that's not the test under the Federal Confrontation Clause or Evidence Rule 803-4. And briefly, the last point I'll make, the third one, is about the sufficiency of the evidence argument. The test is not whether it was accidental or on purpose. The statutes require an explicit purpose of sexual gratification or arousal of either the perpetrator or the victim. And it can't just be that the touching, which is another element of that crime, establishes that purpose element. That would turn it into a strict liability test, which other courts, as we've cited in the briefs, have rejected for that very reason. So, thank you, Your Honors.
With that, the court will take the matter under advisement, issue decision in due course. The clerk will mail a copy of this to you on the day of release. It will also be posted on the High Court website. With that, I'd like to thank both of you for your presentation.